Hey, gun people. This is the oral argument. We haven't got the ruling yet on this New York, the Second Amendment case that went for New York not issuing permits. So I haven't listened to this yet. It should be pretty interesting. So let's see how this goes.
Hear argument this morning in Case 2843, New York State Rifle and Pistol Association versus Bruen. Mr. Clement.
Mr. Chief Justice, and may it please the Court, the text of the Second Amendment enshrines a right not just to keep arms, but to bear them. And the relevant history and tradition, exhaustively surveyed by this Court in the Heller decision, confirm that the text protects an individual right to carry firearms outside the home for purposes of self-defense. Indeed, that history is so clear that New York no longer contests that carrying a handgun outside of the home for purposes of self-defense is constitutionally protected activity. But that concession dooms New York's law, which makes it a crime for a typical law-abiding New Yorker to exercise that constitutional right. This Court in Heller labeled the very few comparable laws that restricted all outlets for carrying firearms outside the home for self-defense outliers that were rightly condemned in decisions like Nunn against Georgia. New York likens its law to a restriction on weapons in sensitive places. But the difference between a sensitive place law and New York's regime is fundamental. It is the difference between regulating constitutionally protected activity and
So this guy is talking pretty slow, and when you're in front of the Supreme Court, you want to get as much information. These guys are attorneys. They can hear if you talk fast. I mean, they've done studies on people tell me I talk fast. When I'm doing these court things, I put it on time and a half. You can still get the gist of what's being said, even if you play things much faster. So this slow talking kind of drags us out, and he's going to lose some time that he can get his point across.
Attempting to convert a fundamental constitutional right into a privilege that can only be enjoined by those who can demonstrate to the satisfaction of a government official that they have an atypical need for the exercise of that right.
So this case is basically about shall issue or may issue. States that have may issue means you have to prove why you want a gun, and then the state gets to decide whether or not they agree that you need one or not. In shall issue states like Texas, you have a right, and the state must issue you a permit unless they prove a reason not to give it to you. So it puts the burden of proof on government in shall issue states. In may issue states, meaning the state may or may not issue you one, it puts the burden of proof on you to prove to the government that you need a license to carry.
That is not how constitutional rights work. Carrying a firearm outside the home is a fundamental constitutional right. It is not some extraordinary action that requires an extraordinary demonstration of need.
I'm really surprised nobody's interrupted him yet.
Petitioners here seek nothing more than their fellow citizens in 43 other states already enjoy. And those states include some of the most populous cities in the country. Those states, like New York, limit the firearms in sensitive places, but do not prohibit carrying for self-defense in any location typically open to the general public. I'm happy to continue by point.
Mr. Clement, sorry to interrupt you.
Just so you know, Clarence rarely asks questions or speaks. I mean, I've watched a lot of these cases, and he doesn't talk or ask questions too much. So I'm kind of surprised he's the first one.
If we analyze this and use history, tradition, text of the Second Amendment, we're going to have to do it by analogy. So can you give me a regulation in history that is a basis, that would form a basis for a legitimate regulation today? If we're going to do it by analogy, what would we analogize it to? What would that look like?
Well, Your Honor, I suppose if you're going to reason by analogy, then you could, go back and you could find analogous restrictions relatively early in our nation's history about prohibiting certain types of firearms or having firearms or any weapon really, in certain sensitive locations. And I think you could reason in that way. Here, I think the reasoning works the opposite direction, which is you typically have a baseline right to carry for self-defense. And the only historical analogs that really restricted the right of a typical law-abiding citizen to carry for self-defense to the same degree as the New York law here were those laws, very few, typically post-Reconstruction laws, that purported to eliminate any right to carry openly or concealed. And those laws were essentially invalidated by every court that was applying an individual rights view of the Second Amendment. And those decisions, of course, were exhaustively considered by this court in Heller, and those decisions were praised for their understanding of the Second Amendment and the relationship.
So he keeps talking about Heller, so I wanted everybody to understand what Heller was. That was when the court ruled 5-4, very close ruling like most Supreme Court. The Second Amendment guarantees an individual right to possess a firearm independent of service in a militia. In Heller, I think they were trying to say, it's supposed to be a well-regulated militia, and only if you're in a militia do you have a Second Amendment right to carry. And Heller said, no. Second Amendment guarantees an individual right to possess firearms independent of service in a state militia and to use firearms for traditionally lawful purposes, including self-defense. They said within the home. I don't like within the home, but whatever. I want you to understand Heller.
Between the prefatory clause and the operative clause, and equally important, those laws were set forth by this court and singled out by this court as the very few restrictions historically that were comparable to what the District of Columbia was doing in Heller.
So if we look at you mentioned the founding and you mentioned post-Reconstruction, but if we are to analyze this based upon the history or tradition, should we look at the founding, or should we look at the time of the adoption of the 14th Amendment, which then, of course, applies it to the states?
So, Justice Thomas, I suppose if there were a case where there was a contradiction between those two, and the case arose in the states, I would think there would be a decent argument for looking at the history at the time of Reconstruction, and giving preference to that over the founding. I think for this case and for Heller, and I think for most of the cases that will arise, I don't know that the original founding history is going to be radically different from that at Reconstruction. But I guess what I would say is I do think that's about where it stops. Because the point here isn't to look at history for the sake of studying history. The point is to look at the history that's relevant for understanding the original public meaning of the Second Amendment and the 14th Amendment.
Mr. Clement, how could it stop there? In Heller, we made very clear that laws that restricted felons from carrying or possessing arms and laws that forbade mentally ill people from doing the same, we, basically put the stamp of approval on those laws. And those laws really came about in the 1920s, didn't they?
Justice Kagan, I think some of those laws in their current form took that shape in the 1920s, but I also think there was a tradition from the beginning for keeping certain people outside of the group of people that were eligible for possession of firearms. I think obviously there was a different tradition with respect to felons, in part because, you start at the time of the framing and most felonies are capital crimes.
That's key. The term felony has morphed over time to where almost all crimes now are a felony. And used to be felonies were only the most serious crimes to where you could get death. Now you can get a felony for writing a hot check over $400. You can get a felony for, hit and run on an accident. I mean, now a felony has been so expanded that it no longer holds this rule that, if you're a felon, you're the worst of the worst, and we have to restrict you from a lot of things.
So, the need to disenfranchise felons for firearm possession was a little different at the framing. So I think you do need to make those kind of adjustments. But I think those adjustments can be made. I think really there are two reasons to at least be skeptical of post-1871 history. I mean, the first is I just don't really understand why it's terribly relevant in forming the original public meaning of the Constitution. But, of course, the second reason is it's just about that time that the collective rights view started to creep into the decisions of some state Supreme Courts. And I think so in Heller's a perfect example that this Court didn't absolutely stop its analysis in 1871, but when it looked at those later sort of post-bellum.
I'm assuming since this guy is talking about these early analysis, he's trying to show why it's not relevant, which means the other side is going to try and make it relevant.
State Supreme Court decisions, the ones that relied on a collective rights view, were given very short shrift. And I think that's the appropriate way to sort of deal with these historical analogs.
Well, I have two questions. One is on history. I mean, it's law of his history. In McDonald, we had professors of history, ran departments in the English Civil War, and they all said the history in Heller was wrong. You've read the briefs here. I don't know. You read the briefs of the historian of the Air Force, and she says it's this way, and the other one said it's the other way. How are we supposed to deal with that? There's a good case. This is a wonderful case.
I'll tell you how you deal with it. It's pretty simple, easy. Your only job in the Supreme Court is to defend the Constitution. That's it. That's your only job, is to hold government accountable to the Constitution. And you have been fucking that up for years. Oh, I'm sorry. You've been messing that up for years. And now you're asking, what are we supposed to do about it? Rule with the damn Constitution. Keep this country free. Hold government in check. That's what you're supposed to do.
Case for showing both sides. So I'm not sure how to deal with the history. My other question is I'm not sure what New York does. We're talking here about outside New York City. New York says we have about 90,000 licenses to carry concealed weapons, or maybe it's 40,000, or maybe it's 10,000. But there's been no trial. There's been no proceeding. All it is dismissal on the. So how are we supposed to find out, A, what the history is, which is my minor question, really. There's a lot of debate on that.
Perhaps you should look at the history of the redcoats that tried to take our guns. Maybe that's the history you could look at.
But second, how are we supposed to know what we're talking about in terms of what New York does, since they say they give, including to one of your clients, they give a license to carry a concealed weapon. So there are concealed weapon licenses all over the place. So what are we supposed to do about those two?
The problem is, Mr. I'm a freaking lawyer with a freaking vest on or a black robe, and somehow I think I'm smart, and now I'm playing stupid. The point is, people shouldn't have to beg government to carry a gun. It should be a God-given right that you can defend yourself, and you can carry a weapon for self-defense. If you violate the law with that weapon, that's a different issue. You idiots think that by making a bunch of laws, you're going to stop people from breaking a law. And that just proves your ignorance. But I digress. Let's see who says next.
Thanks.
Well, Justice Breyer, let me start with the major question, which is, because I think that's actually very straightforwardly answered, which is there's no serious question about the experience of the individual petitioners in this case. And they both sought unrestricted licenses, and they were both denied unrestricted licenses, notwithstanding that they satisfy every other requirement that the state has to be licensed for concealed carry. And so I'm happy to debate why the state statistics don't really prove anything particularly relevant, but I think they're irrelevant for a more fundamental reason. I mean, if there were a debate.
I want to know if they're counting cops as their concealed carry, because they have freaking 50,000 or 60,000 cops in New York. Maybe that's where they're getting that number of the concealed carry, because I don't trust freaking government.
Between the parties about whether 95% or 90% of the citizens of New York were denied their confrontation rights in criminal trials, but you had before you two individuals who were clearly denied the right to confront the witnesses against them. You wouldn't worry about the other 95% or the other 90%.
That's not really the way your brief is written. The way your brief is written is to say, this is a regulatory scheme that deprives most people of the right to carry arms in self-defense. And your brief puts a lot of emphasis on that. Like,
well, why don't we have the stat on how many they denied? You freaking black robe idiots were all ready to say how many they gave. Why don't you show how many they denied, Miss Justice of the Supreme Idiots?
Don't believe the state that they're going to really take seriously people's need for self-defense, because they always reject these licenses. You know, if you had a bunch of statistics which suggests that the state is quite sensitive to people's need for self-defense and gives these licenses a significant amount of the time, you might think differently about the regulatory scheme, wouldn't you? I mean, that's the way your brief reads to me.
Well, Justice Kagan, 2 points. One is I wouldn't feel any differently with respect to my 2 individual clients who were denied their right to exercise their Second Amendment right.
Which is the point. They're the ones that's in front of the Supreme Court, not the 95% that didn't care or the 40,000 that got it. You're supposed to be ruling on the 2 in front of you, not what the others are doing.
But more broadly, the reason I'm so confident that this regime is problematic on its face is because on its face, at least as interpreted by the highest court in New York, the requirement you need to show in order to carry concealed for self-defense, but not for hunting and target practice, is you have to show that you have a need for self-defense that distinguishes you from the generalized community, from the general community. So New York's law on its face says that the only way that you can carry for self-defense is if you demonstrate your atypicality with respect to your need for self-defense.
Because government never wants people to be able to defend themselves, because then you have to rely on government. You have to rely on 911. You have to live in fear, and what government can give you, government can take away. That's why government doesn't want you to have guns. They want to have the market on guns, self-defense, and the use of force. Therefore, you are dependent and beholden to them. Therefore, when they want more money for more cops or more programs, you will be a more willing, pesky citizen to agree to that because you aren't self-sufficient. You need the government, much like the feds are doing now. They're giving out money left and right. Now people can't say no to the money, so they end up doing what the Fed wants. It's bullshit.
So and that's because, look, Mr. Koch can. He has his license. He can carry it for self-defense under the license to and from work. And as you say, can carry it for hunting, target practice, etc. Concealed. And in your opinion, is it supposed to say you can carry a concealed gun around the streets of the town or outside just for fun?
Just for fun. You fucking idiot. Just for fun. I bet you have fucking armed guards. I bet you have a fence around your house. I bet you have armed security guard and the cops on speed dial. Yeah, I bet you get all kind of extra protection. So now when other people want to carry it, it's just for fun. You freaking piece of shit. You're a communist freaking turncoat asshole.
I mean, so what's it supposed to say?
It's supposed to be what New York says that they give to lots of applicants, at least in other counties, which is an unrestricted license, which basically means that somebody who has demonstrated to the state that they're of good moral character, that they have all the necessary training, whatever the state requires.
40,000 or 50,000 or 60,000 is not enough. You have to show you have a good moral character, and then if you just would like to
and the government gets to decide what's good. So if you're good, like a sitting Supreme Court judge, then you have good character. But if you're a working person, then you don't have good character. Who gets to decide what good moral character is? The state, the government. That's the problem, freaking idiot.
Carry a concealed weapon, which is a dangerous thing, as I said. You can just...
It's not a danger. If it's so dangerous, why do all the cops carry it? Oh, because they're safe and trained. That proves more you're a freaking idiot. Obviously, you haven't watched any videos of cops shooting innocent bystanders and firing 15 and 20 rounds and not hitting anything.
Do it just, that's what that's, in your opinion, that's what you want. No restrictions.
Well, certainly New York is entitled to have laws that say that you can't have weapons in sensitive places, in addition to whatever
No, I'm not saying right. I'm not saying.
And New York has those laws, and we don't challenge those. What we're asking for, I mean, one way to think about it is we're asking that the regime work the same way for self-defense as it does for hunting. When my clients go in and ask for a license to concealed carry for hunting purposes, what they have to tell the state is they have an intent to go hunting. They don't have to say, I have a really good reason to go hunting. I don't have to say, I have a better reason to go hunting than anybody else in my general community. And
well, the difference, of course, you have a concealed weapon to go hunting. You're out with an intent to shoot, say, a deer or a rabbit, which has its problems.
You don't shoot deer with a concealed weapon, Mr. freaking ruling on a Supreme Court.
But here, when you have a self-defense just for whatever you want to carry a concealed weapon, you go shooting it around and somebody gets killed.
Oh, my God. Can anybody tell if this is a left-wing, mush-brain, liberal, socialist piece of shit on a Supreme Court?
With respect, Justice Breyer, that's not been the experience in the 43 jurisdictions that allow their citizens to have the same rights that my clients are looking for. This is not something where we're asking you to take some brave new experiment that no jurisdiction in Anglo-American history has ever done.
Mr. Clement, you're talking about 43 other jurisdictions. And I suspect that when we get into those 43 other jurisdictions, that there are going to be a handful that are identical. The one thing that I've looked at in this history is the plethora of regimes that states pick. And that starts in English law, through the colonies, through post-Constitution, to post-Civil War, to the 19th century, to even now. Those 43 states that you're talking about, most of them didn't give unrestricted rights to carry in one form or another until recent times.
Why is that until recent times? Why is that? Because you left-wing idiots have been chipping away at this and giving criminals more power and taking more freedoms away from working Americans and taxing the shit out of us to where we're working more jobs and we're not around our family as much. And now you idiots want to go, oh, well, it's different times and maybe they did it in the past, but you're a freaking idiot too. I can't stand left-wing idiots.
Before recent times, there were so many different regulations. What it appears to me is that the history tradition of carrying weapons is that states get a lot of deference on this. And
meaning I support the left-wing states if they want to be tyrannical, and if the crazy places like Texas want to give out guns, that's their problem. We'll just open the fucking border and flood in illegals and not let them build a wall and run 1.5 million people since Biden been elected through the border that are gang members and transporting drugs, etc. And then when the shootings go up and there's more self-defense cases, we'll say, see, look at Texas. They're shooting everybody because they have too many guns. That's what you want, you freaking idiots.
The one difference that you haven't addressed is the question presented is what's the law with respect to concealed weapons. In 1350, the British Parliament specifically banned the carrying of concealed arms.
In 1776, we ran the British the fuck out of here because they wanted to do that shit here. I don't give a shit what British Parliament did in 1315. Why are you bringing up that, you freaking idiot? I just can't believe the people that we have in charge of this country right now.
In colonial America, at least 4, if not 5 states restricted concealed arms. After the Civil War, there were many, many more states, some included in their constitution, that you can have a right to arms but not concealed. You can go to Alabama, Georgia, and Louisiana, which are now more open, are more free in granting the right to carry guns, but they prohibited, through their history, concealed weapons, the carrying of concealed weapons. It seems to me that if we're looking at that history and tradition with respect to concealed arms, that there is not the same requirement that there is in the home.
Notice she's filibustering and taking up all his time. You notice that? Because he's pro. Let's see if they filibuster on the other guy. Notice she's just talking and talking and talking, and he's only got so much time. Once he goes up there, the clock starts. And then when his time's up, he's off. So if they talk the entire time, he may only get 2 sentences out. That's bullshit. Left-wingers cheating and scamming the game for their left-wing politics just like they do until they destroy this fucking country.
One of the things Heller pointed to was there were few regulations that prohibited the carrying or the keeping of arms in homes. But that's not true with respect to the regulations about keeping of arms outside of homes. Putting aside the prohibitions, regulations on sensitive places, regulations on the types of people.
Types of people. Yeah, like black people. Because black neighborhoods are traditionally much more violent and they have much more shootings. And the left can't say that they don't want black people to have guns, but that's exactly what gun control is. We can't let those black people have guns because they're irresponsible, they're stupid, and they shoot up their own neighborhood, and we're losing voters every time they kill each other. So we need to get rid of the guns because we can't control those stupid black people. That's what gun control is, people. I'm not saying that. They're saying it.
It seems to me that I don't know how I get past all that history.
Well, you know how you get past it? You let police carry guns around so they can defend themselves. You let police carry guns when they're off duty so they can defend themselves. Why not the pesky citizen? If you want gun control so freaking bad, take the guns away from the people that protect you. And then let's see how much you want guns gone, you freaking idiot.
Well,
Without you sort of making it up and saying there's a right to
So now he's just making it up because he's pro-Second Amendment.
control states that has never been exercised in the entire history of the United States as to how far they can go in saying this poses a danger.
So, Justice Sotomayor, there's a lot to that question. I'll try to take it, sequentially if I can. I mean, let's start with concealed carry restrictions.
She's not going to let him finish. I guarantee you. She'll interrupt him again.
I mean, it is true that during time periods where open carry was allowed, that some states did specifically restrict concealed carry on the precise theory that if we allow you to carry open, then if you're carrying concealed, you're probably up to no good. And Heller did exhaustively survey those cases. And what it concluded is that if a state allows open carry, then it can prohibit concealed carry. I suppose vice versa.
But you're asking us to make the choice for the legislature. We're only looking at concealed here.
Oh, so now we're only looking at concealed carry, but you're going back to 1315 when the British outlawed their citizens. Really? You freaking idiot.
We are not asking you to make that. And
Well, you are, because you're conditioning his.
Notice she keeps interrupting to eat up his time. We don't want you to make a good argument. We already have our mind made up. We're just doing this for show.
History on a different fact.
I don't think we're asking for anybody to make that choice. In fact, the relief we've asked for is to have an unrestricted license because under New York law, as it currently exists, that's the only way that you can have a carry right for a handgun. But in framing our relief in the complaint, we, framed it so that there are other relief consistent with the decision. So if New York really wanted to say, no, we have a particular problem with concealed carry, notwithstanding that traditionally that's the only way we allow people to carry. If they want to shift to an open carry regime.
That's a very good point. New York does not allow open carry. They allow some to conceal carry, but they don't allow anybody to open carry. See, constitutional carry is you can open or conceal. You don't need the government's permission. That's where the states ought to be. That's where most states are going. Texas just went there this year. It took us way too long. Arizona's that way. There's a lot of, I think there's like 30 states maybe that have constitutional carry. Maybe it's different. I don't know the exact number. But a lot of states are just going, you know what? We don't need to be doing backgrounds and checking. If you go out there and carry a gun and don't do anything wrong, what's the problem? If you do something wrong, we'll charge you and we'll deal with it. We ain't checking the people coming across the border, 1.5 million people whether they have a concealed carry. We can't even have them put on a mask. We can't even require them to get a vaccine. We just let them run across the border and say, oh, no, they're exempt. They're poor migrants, and it's going to help the liberal cause when they start voting left. Disgusting what our country's turning to.
They could do that consistent with everything we've said here. Now, I don't think anybody expects that to happen, because if you look at the New York law specifically, it's a law that prohibits the carrying of handguns except for permit holders. And then its provisions about permit holders speak specifically to concealed carry. So that's why we've framed our request the way we have. But what we're doing, I think, is completely consistent with the majority decision in Heller's analysis of the historical cases, which said that those very few states that tried to prohibit both concealed carry and open carry, and so gave no outlet for the right to carry a firearm for self-defense outside the home, those were the laws that the Heller majority identified as being analogous to the D.C. restriction in Heller that was invalidated.
I do know that many of the laws.
Let's interrupt and filibuster. Let me talk about a bunch of bullshit so I can eat up some more of your time.
Conditioned retain the right of the state to decide.
The right of the state. The right of the state shouldn't trump the right of the people. That's the problem. Government thinks they're much more important than the freaking people that they rob from and tax and treat like shit.
Which people were eligible. And the historians to carry the arms, that you had to be subject to the approval of the local sheriff or the local mayor, etc. And during the Civil War, that was used to deny black people the right.
Oh, so now there's a problem with denying black people. So we can't say that we don't want black people to have guns. We can just say gun violence in predominantly black neighborhoods by black people are so out of control that we need to restrict guns from everybody. Because if we just said black people, we'd be just like them. Freaking hypocritical left wing.
Right to hold arms. We now have the 14th Amendment to protect that. But why is a good cause requirement any different than that discretion that was given to local officials to deny the carrying of firearms to people that they thought it was inappropriate, whether it was the mentally ill?
You mean mentally ill like you? You freaking idiot. Just support the Constitution and quit with your left-wing bullshit.
Or any other qualification. That's how I see the good cause, as fitting in within that tradition.
So let me make a point about how it's so different from that tradition, but then also let me make a historical point. It's radically different to say that if you are a typical New Yorker, so you satisfy every other qualification, you're not a felon, you don't have any mental health problems, you've done everything else we've asked you, but you are typical in the sense that you don't have an atypical need to carry for self-defense. I don't think there's any historical analog to that. As to the historical examples, with all due respect, I don't think I read the surety laws the same way that you do.
Anytime I say with all due respect, they're about to tell them they're full of shit. So I don't think the surety laws the same way you do. I think you got it wrong. You're a freaking idiot. But I can't say that, so I'll say with all due respect.
Those surety laws, which were only in place in a minority of jurisdictions, but nonetheless, I think they help us. Because those surety laws, first of all, start with the proposition that there's a baseline right for every person, every member of the people protected by the Second Amendment to carry. And what they do is if somebody essentially as a complainant can come into court and say that somebody has a propensity to use them in an offensive or violent way, then if you satisfy a neutral fact finder, then you don't automatically get to disarm that person. You put them to the choice of posting a surety, and then they can continue to possess their firearms.
Mr. Clement, in your opening, you talked about the right applying in any location typically open to the general public. I'd like to get some sense about what you believe could be off limits, like university campuses. Could they say you're not allowed to carry on it?
So now you want the guy that's arguing to limit restrictions, you want him to tell you what he thinks should be off limits. You don't want to ask me that question. I don't give a shit where it is. So what if it's a campus? I don't care. So what? I don't care. People carry things and they don't use them in bad ways. People drive cars on campuses and they don't run people over. Because a drunk goes out and kills somebody, you want to get rid of cars on campuses? Of course not. It's only when it comes to that damn gun that takes away the power from you elite idiots.
The university campus.
So, Mr. Chief Justice, I think the answer to your question is yes. And I think that what I would say, though, first of all, is the language I was talking about, any location open to the general public, that's right from the license denial on Joint Appendix page 41. So there wasn't loose language on my part. That's right there from where we are told in capital letters where we cannot carry. Any location, all caps, typically open.
Well, what sort of place do you think they could be excluded from? In other words, you can get a permit, but the state can impose certain restrictions. For example, any place in which alcohol is served.
Oh, so I can go home and drink alcohol, I can go to a park, I can go to a friend's house and drink alcohol, but because the government gives licenses to alcohol establishments, we're going to restrict those places from carrying. Really? Yeah, because you idiot citizens are so irresponsible, you need us, smart people, to protect you because you're all a bunch of idiots. I am so freaking tired of tyrannical government in this country.
So they say you cannot carry your gun into any place where alcohol is served.
So, Mr. Chief Justice, I think probably the right way to look at those cases would be look at them case by case and say, okay, in this court in Heller, for example, said sensitive places include government buildings and schools.
Why don't they want people carrying in government buildings? Maybe that's because where government works. Maybe because they know they're pushing the damn limits. I got news for you idiots. You can make all the laws you want about guns not in government places. When a criminal decides to go into a government place and shoot and kill people, he's not going to give a shit about your dumbass laws, which is why all your dumbass laws are dumbass.
I think those you can probably tap into a pretty good tradition. I think any place that served alcohol would be a tougher case for the government. I think we would have a stronger case. They might be able to condition the license holder on not consuming any alcohol. There might be a variety of laws, and we could have those debates. But
what about the football stadium?
What about a football stadium? Cops are allowed to carry in a football stadium. Retired cops, I can carry in a football stadium. The pesky citizens can't carry. Why? Why? Because government's the good people, Rick. Government has special privileges. We're smarter than the rest of the idiots. It's pathetic.
I think, again, football stadium, you probably take it on its own and look to the historical analogs. But here's, I guess, if I could offer some general principles. I think there's two principles. One is, restriction of access to the place is something that I think would be consistent with the way government buildings have worked and schools have worked. Not any member of the general public can come in there. They restrict access with or without a gun. If you're an adult that has no business to be in a school, you're excluded. So I think that's a factor that would support treating that as a sensitive place. A second principle that I would offer is these sensitive place restrictions really are a different animal than a carry restriction, because I think a true sensitive place restriction is not just going to limit your ability to carry concealed, but it's going to be, say, this is a place where no weapons are allowed.
Unless you're government. Because government doesn't have to follow the laws because they're special and smart, and you idiot pesky citizens are stupid and need us to make laws so that we have power over you so we can protect you.
Whether they're firearms or other weapons, no weapons are allowed. And then the third point that I would say, and this is just an analogy, but I think it's a useful analogy, is I think the way to think about this is a little like the non-public forum doctrine in the First Amendment, which is you start with the place and you try to understand, is this a place where, given the nature of the place, its function, its restrictions on access, that weapons are out of place? And if so, that's probably a sensitive place where the state can say.
But I think what the Chief Justice is trying to do is figure out how those cash out in the real world.
Well, if we're going to restrict weapons from dangerous places, why do we let cops bring weapons to domestic violence or to robbery? Because those are dangerous places. And if you bring a gun in that situation, you're probably going to have to use it. So why does government allow cops to bring guns in a dangerous? Well, Rick, they're there to protect you. Bullshit. We saw the cops stand outside the school while a guy was in there shooting unarmed kids. And the court said they have no duty to protect. If government has no duty to protect, why do they need to carry guns to dangerous places? Why don't we just say there's no firearms, just like we do to the pesky citizens?
So I'll give you a few more. New York City subways.
So,
Look, if you leave it to a fucking liberal, they'll outlaw every fucking place except your home. You can't bring it in a bathroom because somebody else might shit loud and it might disturb you. And if you got a gun, you might shoot them because they farted too loud. If their shit stinks, you might shoot them. We need to keep guns out of toilets. Why don't you guys take that up, you fucking idiots?
I think that the question of whether you could restrict arms in the subways, you'd have to go through the analysis, I think, and say, is there restriction on access generally? I suppose.
No, I got the analysis, okay. All three parts of it. Like, how does it cash out? What does it mean?
I don't know how those are going to cash out in particular cases, because I think the way that you would normally deal with that is look at all the briefing we had in this case on the history of these various things. And so, on behalf of my individual clients, I suppose I could give away the subway because they're not looking to go, they're not in Manhattan, they're in Rensselaer County.
The Chief Justice started with universities, and you said that would be all right. Did you mean that?
Yeah, yes, I did mean that.
Because that's open for, anybody can walk around the NYU campus.
Well, NYU doesn't have much of a campus.
I would go back to New York, and I think you'll find that that's wrong. Similarly, the Columbia campus.
Columbia's got a campus, and I don't know whether they restrict access at all. And maybe, if they don't restrict access to parts of the campus, maybe those are parts of the campus where they wouldn't enforce the policy anyways. The point I'm trying to make,
but you can't say, there are 50,000 people in one place, a ballpark. There are 50,000 people in one place. They're all on top of each other. We don't want guns there.
Why? Who gives a shit what you want? Cops carry guns there. Off-duty cops carry gun there. People with concealed permits carry gun there. Well, I guess concealed, they restrict it from concealed. There's plenty of guns in those places. Oh, but Rick, those are government people. They're the good people. We just don't want the pesky citizens.
That's, you couldn't, the city or the state couldn't do that?
I think they might well be able to, because again, you can't get into Yankee Stadium without a ticket. I'd have to understand many of these, I don't know every jurisdiction. I don't know enough about Yankee Stadium, but, a lot of these stadiums are not run by the government anyway. So if a private entity wants to restrict access, I don't know where the state action is for them to be.
Bingo. Why does a state need to make blanket and get their freaking dirty paws in this situation? If a business don't want people carrying, then they can say it and we'll restrict it. The reason why businesses would rather government do it because they know they won't be held accountable, and it's not us, it's just the government. And that's a big excuse to give government power so idiots that respect government and that comply with government can say it's not my fault, I'm a good person, it's government that's making me do this. Just like they're doing with COVID and the vaccine and losing your damn job.
The state says no protest or event that has more than 10,000 people.
I think that might.
Do cops carry guns at protests? Oh, that answer would be yes.
Be trickier. Maybe they could justify that under strict scrutiny, but I don't think that would be a sensitive places.
But why not? I mean, I guess it's about the level of generality. All these questions that Justice Kagan's asking you or that the Chief asked you.
Jeez, we got all these women wanting to protect everybody. All these poor women have to protect their children and keep you safe. And they're smart now, and they're going to make a difference and protect you. We're going to get mothers against drunk drivers and mothers against guns and mothers against concealed carry. And we're going to change the world and make it better. Freaking idiots.
If you concede, as I think the historical record requires you to, that states did outlaw guns in sensitive places, can't we just say Times Square on New Year's Eve is a sensitive place because now we've seen, people are on top of each other, we've had experience with violence, so we're making the judgment. It's a sensitive place.
So here's what I would suggest.
If government had their way, every place is a sensitive place except your home. And they would take that away too. But I think government will concede if you say every place is sensitive except your home, we'd be okay with that. We don't want you carrying a gun. We only want our government thugs carrying guns so we can enforce our will upon you and you can't fight back or defend yourself. And then when there's riots and out of control chaos and your neighborhood is turned into a war zone and places are being burnt and government pulls out because they're the only one with guns and they go, tough shit, you're on your own. That's what they like. That's what they like.
But the right way to think about limiting guns in Times Square on New Year's Eve is not as a sensitive place, but as a time, place, and manner restriction. And that might be a perfectly reasonable time, place, and manner restriction. But I don't think that's the sensitive places doctrine as I understood it from, and obviously it's a brief reference in the Heller decision, so I may not fully understand it. But I understood that those were certain places where there were just no weapon zones all of the time because of the nature of that institution.
I wonder if shit hits the fan when American people have enough and decide to say that our government is no longer protecting our interests and it's time to remove our crooked government like the Constitution says. I wonder when and if that happens, if anybody's going to care about these no gun carry zones. I wonder if people will be like, yeah, let's revolt. Well, we can't go to Times Square because it's against the law. Yeah, that's it. Freaking idiots. Keep passing your laws. Keep overreaching. Keep tightening your grip on the pesky citizen. See where it gets you.
And I think it's probably worth thinking about rallies and Times Square. There may be restrictions, but they would be done under the rubric of time, place, and manner.
Could we start with the purpose of the personal right to keep and bear arms? And the core purpose of that right, putting aside the military aspect, is self-defense. So starting with that, could we analyze the sensitive place question by asking whether this is a place where the state has taken alternative means to safeguard those who frequent that place?
Oh, yeah, that makes perfect sense. Like, you mean like schools where they have school shootings? You mean like every place there's a mass shooting that is a no-gun zone and guns are outlawed? Like every place like that? Is that where you're talking about? Where the government takes alternative safeguard? Yeah, is that what you're talking about?
If it's a place like a courthouse, for example, a government building where everybody has to go through a magnetometer and there are security officials there.
You mean security officials who have guns, right? Because they're protecting you.
That would qualify as a sensitive place. Now, that doesn't provide a mechanical answer to every question, and but would that be a way of beginning to analyze this?
Justice Alito, that might be a way of analyzing it. The reason I'm a little bit reluctant to go that route as opposed to really think about the nature of the place and the restrictions that are associated with its core activity is because I worry that if you went that direction, then the state would say, well, you know, this part of the city, we have a lot of police officers, and so you really don't need to exercise your own individual self-defense right there because we have your back. And I don't think that's...
I don't know what those places would be, but continue.
Well, I think my friends would tell you that, you know, the whole city of New York is that way. And I think there are a lot of people in New York, and New York may have a lot of reasons to have regulations that are a little bit different than in upstate New York where my individual petitioners reside. But I don't think that they can take all those people in New York and deny them of their fundamental constitutional rights.
How do we do this?
Justice Breyer?
How? I mean, so far we've been, to my mind, I think NYU does have a campus. You're not certain. All right? You think that in New York City, people should have considerable freedom to carry concealed weapons. I think that people of good moral character who start drinking a lot and who may be there for a football game or some kind of soccer game can get pretty angry at each other.
Oh, so somebody drinking in their home, because here's the next step, people. This is how government encroaches. See, this sounds really good now, but pretty soon it'll be like, you know what? People drink in their homes doing sporting events. And we should be able to take guns from your home because we know you're going to be drinking and watching football, and you might get pretty angry. Such bullshit.
And if they each have a concealed weapon, who knows? And there are plenty of statistics in these briefs to show there's some people who do know. And a lot of people end up dead. Okay?
A lot of people end up dead by law enforcement who carry guns. A lot of people end up dead by law enforcement shooting someone else and missing and hitting them. Okay?
So, what are we supposed to do? To sort of float around? like with NYU, and say, hey, this is the rule. It seems to work out in upstate New York. We don't know, of course, and we do know that your client is carrying a concealed weapon.
Anybody see a way that this court might be leaning on this case?
Because he has a right to, in some instances, and even following Heller and following the history, which I thought was wrong. Even so, what are we supposed to say?
If he thought Heller was wrong, making an individual right to carry, how do you think he's going to rule on this?
In your opinion, that is going to be clear enough that we will not produce a kind of gun-related chaos.
Oh, here we go. It's chaos out there. Look at Texas, the most armed state in the freaking world. Everybody has multiple guns, concealed carry, open carry. Yeah, complete chaos. Not to mention that the government, the federal government, where you idiots and clowns work for, are opening the border and letting 1.5 million people, drug dealers and gang members, come through the border. Yeah, let's not even mention that, because if you let them in, then people have to defend themselves. Then we can claim, see how much shootings there are? Look, they got a lot of guns. Look at the shootings. It went up. Freaking idiots. Don't never, ever believe a damn thing one of these government flunkies tell you.
So, Justice Breyer, I would sort of point you to two things that maybe would give you some comfort. I mean, one is the experience of the 43 states, and there are amicus briefs on both sides getting into the empirical evidence, but there really isn't the case that those 43 states that include very large cities like Phoenix, like Houston, like Chicago, they have not had demonstrably worse problems with this than the 5 or 6 states that have the regime that New York has. So that's one place to look. The other place that I think you would find...
And that makes a very good point. It's not that good people have guns. It's that bad people will always do things with guns, and you shouldn't be blaming and penalizing good people and taking away their right to defend themselves from the bad people. Because you idiots, no matter how much government you get and how many cops you get and how much larger you make government, you just can't protect people all the time, everywhere, even though you like to think you can. And when you fail, you blame it on someone else.
Something persuasive there is their own amicus brief on their side by the city of Chicago. Because the city of Chicago is in a shall-issue jurisdiction. And the city of Chicago goes on to sort of, essentially brag about all of the ways that they've done consistent with that regime to reduce crime in Chicago that probably doesn't have a direct analog in downstate Illinois. But of course, one of the problems with this case...
I mean, most people think that Chicago is like the world's worst city with respect to gun violence.
Yeah, but it's not gun violence by lawful people carrying guns. It's from thugs, gang members, and other people that you don't want to lock up, and you can't say they're black because you're racist. You can't lock them up because you'll be racist, and you can't say it's a black crime issue because you're racist. So what do? You attack lawful people who carry guns that didn't do a damn thing because you're a left-wing fucking loon.
Chicago and their corporate...
Chicago doesn't think that, but everybody else thinks it about Chicago.
And nobody thinks that about Phoenix, and nobody thinks that about Houston, and nobody thinks that about Dallas, and nobody thinks that about San Diego.
I wouldn't think San Diego's a shall issue. Is it really? I'd be shocked. Wow. San Diego is a shall issue? I had no idea. Wow.
Which, even though it's in a restricted state, is a shall-issue jurisdiction.
Thank you, Mr. Clement. Justice Thomas, anything further?
Mr. Clement, where does Mr. Nash live?
Mr. Nash lives in Rensselaer County, New York.
Is that close to NYU?
That is nowhere near NYU, Justice Thomas. And, I think if you look at the county website, they talk about their 153,000 people spread over 955 square miles. And yet that's the context in which my individual clients are being denied their Second Amendment rights.
Justice Breyer, anything further? Justice Alito? Justice Sotomayor?
Counselor.
Oh, of course. She had to freaking get her mouth running.
Your client is permitted to, Mr. Nash, one of the two, to carry when engaged in outdoor activities of any kind, like camping, hunting, and fishing on back roads. With the few substantially lesser number of people.
The number of people have nothing to do with an individual right to protect yourself. Not only does it have nothing to do with it, it makes the right even more important, because when you're in a group of large numbers of people, the likelihood of crime or bad people being in that large number of people goes up. So your chance of being assaulted, robbed, or a victim of a crime goes up substantially when you're around larger numbers, and you freaking idiots are trying to make it the opposite.
Tell me how many places in Rensselaer County does your client have a self-defense risk?
Well,
I mean, at what point do we look at the restriction and the burden it places? Meaning, yes, I'm sure it has a center of town. I'm sure it may have a shopping center or two. But it's not like he's totally restricted from carrying a gun. He's just restricted from carrying one basically in those sensitive places.
Why don't we just make it to where you can only drive in sensitive places, Judge? Why don't we just make it so you don't really need to drive downtown and you don't really need to drive to work? You can take public transportation. So we'll just make driving a privilege that the state can determine whether the risk of having all these cars, because people do bad things with cars, and that we can just start restricting where people drive in order to keep them safe. The ignorance of you people are just overwhelming.
Because the rest of his home is pretty distant from other homes.
So, Justice Sotomayor, just so we start on the same wavelength or the same page, literally page 41 of the Joint Appendix, this tells Mr. Nash where he can carry concealed. And what the officer, McNally, told him was, quote, I emphasize that the restrictions are intended to prohibit, italicized, you from carrying concealed in any location, all caps, any location, typically open to and frequented by the general public.
Wow, that's not too generalized. So any place that there's a public, a cop can arrest you saying you can't carry because general public frequent. Yeah, that's not too generalized. These freaking justices are okay with that because it gives government and state power. And they don't want to lose their power, therefore they must support other people's power. Freaking turncoats, every one of them.
Now, I would submit that's a pretty broad number of places in Rensselaer County, and it would include, I fear, most of the roads in the county at night when you're traveling and might think that you have a need. I mean, if Mr. Nash has a relative whose car breaks down and has to have a change of tire and he wants to go out and assist them with that and wants to make sure that he is in a position to defend himself, I don't think he can do it consistent with this license restriction. And at the end of the day, I think what it means to give somebody a constitutional right is that they don't have to satisfy a government official that they have a really good need to exercise it or they face atypical risks.
Justice Kagan, anything further?
Mr. Clement, you said, I think in passing, that it would be fine if New York banned open carry so long as it allowed concealed carry. Is that correct?
Certainly that's consistent with the relief we're looking for. We're looking for some outlet to exercise our constitutional right to carry firearms outside the home.
How is it consistent with the history? I mean, the history seems very clear to me that it's sort of like the exact opposite of how we think about it now. In other words, that there are lots of places that wanted people to display their arms as a matter of transparency, and what they prohibited was the concealed carry. So I'm thinking, like, if you look to the history, you end up with a completely different set of rules from the ones that you're suggesting.
So how does history change if you just follow history? Is that what you're telling me? We should follow what the Redcoats did, right? We should throw away our Constitution and just accept what the Redcoats were doing was good, and that our founders were bad for breaking away and revolting against the Redcoats. Is that your idea of following history? You freaking moron.
With respect to concealed versus open. And it's an example, I think, of the difficulties of looking to history, where people were operating on such different, to use your term, wavelengths?
So, Justice Kagan, first of all, I would have thought that, we'd sort of cross the bridge to use history in this context in Heller. But if we're going to look to history, I actually think
Mr. Clement, the question is how to use history. And, where do you look? How far do you look? Do you look to the 1920s when all these felon laws were passed, as well as public purpose laws of exactly the same kind as New York? So one question is how far up do you look? Another question is, with what sense of flexibility do you look? And I think that this is an example of that. It's like,
Okay, I'm going to pause this here because I'm at an hour, and we'll make a part 2. It's probably going to be a part 3.